Welcome back, America. I'm Hugh, joined by Bret Stephens, one of America's finest columnists. He writes for the New York Times. Good morning, Bret. How are you?
Hugh, I'm fine. How are you doing?
I'm good. I want to talk mostly about your column of May 3rd, overturning Roe is a radical, not conservative choice. But before I do, since we agree on international issues a lot, let me play for you the president in Japan this morning with the Prime Minister of Japan at his side. Can we play that cut for him, please?
We agree with a one China policy. We signed on to it and all the attendant agreements made from there. But the idea that it can be taken by force, just taken by force, is just not appropriate.
Are you willing to get involved militarily to defend Taiwan if it comes to that?
Yes.
You are.
That's the commitment we made.
I see very smart people like Gerard Baker, Jerry Dunleavy saying the White House is already walking this back. Bret Stephens, what do you make of this?
I think it's the right call by the president. I'll tell you why. The one China policy is increasingly a dead letter. I wish it weren't, but that was a change that was really brought about by Xi Jinping at the 70th, or I guess it was the 100th anniversary of the Communist Party last year. And when posed with this kind of direct question in the midst of the Ukrainian war, if he had said anything other than that, I think it would have been a moment like 1950 when ambiguity from the United States invited communist aggression in Korea.
So, I agree with that, Bret. That was Dean Acheson at the Press Club in 1950, and a lot of apologists have said he didn't mean it. But you're right. The moment and the question called for that kind of clarity, and I think the White House staff walking it back is inimical to the idea that Joe Biden is president.
Yeah, no, I think they're making a mistake here because they're playing into the suggestion that the president is not in control of his wits or his mouth or his mind or whatever, which at this moment in time is problematic for deterrence. I think, given the question that he was asked, the president said the right thing. I hope the message was heard clearly in Beijing.
So we agree, and we agree completely. Let's talk about where we disagree. Your column of May 3rd. People can go and read it. I'm not going to selectively quote. How would you summarize, Bret, your position on Dobbs as it looms? It might be released in the next hour, as a matter of fact.
Yeah, well, it'll be interesting to see what happens. My view was that Roe v. Wade was incorrectly decided in January of 1973, nearly 50 years ago. But it has been the law of the land for a half century, and I think that overturning it now, as seems likely from the leaked draft of Alito's opinion, would be a radical and not a conservative decision that would have unintended consequences, which we conservatives would regret.
Now, what I want to talk to you about is the term radical. I've been teaching con law for 25 years, Bret, and I don't want to throw case names at you. But my view of the reason that you are incorrect in this assessment is that Roe was effectively overruled by Casey, where the three-judge joint opinion of Souter, Kennedy, and Justice O'Connor attempted to impose and implored the country to accept a solution that said basically 4.5 to 5 months, no restrictions, and thereafter any restriction goes. You say that is, in fact, the anchor on which people ought to stand. Is that a fair character? That it's radical to overturn Casey, not Roe, because Roe is effectively the dead letter.
Well, I don't agree with you that Casey overturned Roe, and I don't think Brett Kavanaugh would agree with you that Casey overturned Roe. He called Casey precedent upon precedent during his confirmation hearing. I think Casey amended Roe in that it changed the substantively changed the trimester scheme on which Roe had initially been based, but abortion rights were substantially left untouched in the wake of Casey when it appeared that they might have been overturned. And by the way, in 1990, what was it, when Casey was decided, and Roe was less than 20 years old. I think if Casey had gone the other way, if Kennedy and Souter hadn't changed their minds in that decision, I would have less of a problem. I would have had less of a problem then. My contention here is that we have had what amounts to a settled law for 50 years, and change from above, decided by 2 or 3 unelected justices of the Supreme Court, would be so extraordinarily disruptive to the way in which Americans, and particularly obviously American women, understand their reproductive rights, that it would be precisely the kind of change that we conservatives usually object to, which is an unelected body deciding, like philosopher kings, to change the way we understand our constitutional rights. Now, you can make the argument. That Roe, that abortion never should have been a constitutional right, and that it was a bad decision, and therefore, like, say, Plessy v. Ferguson, another bad decision. It doesn't matter how much time has elapsed; it needs to be overturned. But the difference there, Hugh, I would say, is that what happened with Plessy, which gave birth to the evils of Jim Crow, is that Plessy withdrew rights that had been advanced to African Americans, and then Brown, starting with Brown v. Board, those rights were restored. What you have in this case is a right that has been advanced that is now being withdrawn, and I think that's fundamentally different.
And the response, and I just want to take a minute. I don't want to throw case law at you, but I've got to, because I just don't think you know this, is that the right that's being restored with the Dobbs draft is the right of the people to decide this question as they deem fit in their states. What's being restored is federalism. And what part of your argument that is missing is that it is not settled since 1992. In fact, you left out Stenberg v. Carhart and Gonzalez v. Carhart, a 2000 decision and a 2003 decision. My guess is you don't know those cases. Am I right about that, Bret?
Yeah, no, I don't pretend to be a constitutional scholar, so I don't know.
Okay, see if this informs, not many people do. In Stenberg, Nebraska passed an abortion law, an anti-late term abortion, partial birth abortion law, and it was struck down as unconstitutional despite the Casey standard that was supposed to settle it. Justice O'Connor switched to the liberal side. Justice Kennedy dissented and was outraged because he said, we settled this in 1992, and basically, Sandra, what are you doing? In 2003, in Gonzalez versus Carhart, when the court had changed again, the late term prohibition of the Congress was upheld. And so what you saw was Kennedy trying to restore the standard of 1992, the Casey standard. But in fact, what was on display is that it's a political football that hasn't been settled in 50 years. And the right we ought to restore is that of the people to decide. As Churchill said, trust the people. So until and unless your argument accounts for the Stenberg and Gonzalez take back, the left's attempt to unsettle what was supposedly settled in 1992, it's not radical to say we see what the left is doing and we're going to play the same game, which is to ask the court to get out of it, because the left never will.
Hang on a second, okay? Because what you're talking about is essentially fiddling or questions of abortion rights at the margins, not the central right across the United States for women to have access to a legal abortion within some sorts of parameters. Second case you're making about federalism is one I'm perfectly familiar with. I understand the argument the argument on the conservative side that this is a matter that is best left to the states. Now, if you're one of the ironies of that view is that if your concern here is that the people should decide at the level of states, then you are potentially licensing unrestricted abortion laws that go far beyond the standards set in Roe and Casey to allow what would practically amount to infanticide in some of the most liberal cases, which is probably not a consequence that most opponents of Roe v. Wade have in mind.
Well,
Secondly,
Bret, that is
but the, but,
pause
the,
for a
but, the,
second.
but the question of federalism is also an important one, because federalism exists within certain limits, including the due process clause of the 14th Amendment. And one of the interesting things I find in reading Alito's case is his argument is that basically Roe was just too recent a vintage, which is to say 50 or 49 and a half years, to be considered a kind of a foundational right in the way that some of the other implied rights granted by the 14th Amendment are foundational rights. I would simply argue with that. 3 generations of women have come of age understanding that a right to an abortion is a right that they enjoy as a constitutionally protected right. You withdraw this, and I think the consequences to our understanding of rights and to the standing of the court is going to be dramatic, and we're going to rue it in the way that we now rue taking Baghdad.
Now, let me talk to you about the first point. The constitutional licensing of late-term abortion and practically infanticide already exists in blue states like California that have constitutionalized it. And indeed, women can have abortions up to the day before birth and indeed during birth. That is the law of the land in California and in other jurisdictions that choose what I think to be morally reprehensible, but nevertheless are reflective of the political culture of that state. So what your first argument, it's a non sequitur because that already exists. We're not licensing that via Dobbs. No one is licensing anything. The political argument moves. But what you don't, I don't think you just deal with it, Bret, is that the argument, 3 generations of American women and 3 generations of American men and all generations of American citizens have grown up with a political football. The only march that every year draws 500,000 people is the pro-life march. It has never been settled. It is always the subject of choice and change, and states continue to throw up attempts to overturn Casey or the, quote, settled law, even as states continue to throw up expansions. The only thing that has been constant is the political conflict set off by Roe. And the only way to get out of that particularly thick woods, which is destructive of comedy and common sense, is to let the people decide. And we will have a patchwork of laws like we do on, for example, every other fundamental right, voting. But what Alito said about fundamental rights analysis is and has been true. The other fundamental rights, like the right to contraception, is rooted in the right to control your family, which dates back to the 20s and beyond at the time, and they existed at the time of the passage of the 14th Amendment. You get a minute to the break, Bret, and then so go ahead.
Well, I'm actually not entirely clear why exactly, after overturning Roe, the court also want to overturn Griswold on precisely the same standard that Samuel Alito has set, which is that this is a right to privacy found nowhere in the Constitution. Right, the right to privacy, as far as my reading of the Constitution suggests, doesn't exist. And so it actually opens the way to overturning in some states those rights. I think
when we come back, we'll talk about what happens when a political settlement occurs post Griswold. There is no one anywhere proposing the repeal of Griswold or the repeal of Obergefell. We need to take account of the facts as they exist. And when a settlement occurs, the settlement abides. It has never occurred with Roe. Bret Stephens is my guest. I'll be right back after the break, America. Stay tuned. Welcome back, America. I'm Hugh Hewitt, live inside the Beltway, talking with New York Times columnist Bret Stephens about his May 3rd column about the Dobbs decision. He opposes as radical Justice Alito's draft decision. And he said this, I want to quote this one line. This is partly a matter of stare decisis, but not just that, you wrote. As conservatives, you are philosophically bound to give considerable weight to judicial precedents, particularly when they have been ratified and refined as Roe was by the 1992 Planned Parenthood v. Casey decision over a long period. We talked about that, but we haven't talked about stare decisis yet, Bret. And I want to begin by talking about Citizens United. Did you support the decision of the Supreme Court in Citizens United, which struck down most of the McCain-Feingold Act?
Yes, but I'm having second thoughts about the decision.
Okay, but that's a political policy, right? You might want to try and, it's a First Amendment decision, and Chief Justice Roberts did not write the majority opinion, but he concurred wholly in it. And he wrote about, and I would recommend to you his 2010 decision about what it takes to overturn a 30-year precedent, which is what they did they overturned the Austin case.
Yeah.
And so what he wrote is, quote, stare decisis is the preferred course because it promotes the even-handed, predictable, and consistent development of legal principles, fosters reliance on judicial decisions, and contributes to the actual and perceived integrity of the judicial process. And he says it is not a mechanical formula, citing, among other things, Lawrence v. Texas, which was overturned. That was the 1986 decision upholding anti-sodomy laws that was overturned a decade later. If it were, segregation would be legal, minimum wage laws would be unconstitutional, and the government could wiretap ordinary criminal suspects without first obtaining warrants. So the stare decisis decision of 30 years, you're arguing 30 years is enough. Unless you came out saying that Citizens United was radical, you've got two standards for two different areas of law.
Well, hang on a second. What I write is this is partly a matter of stare decisis, but not just that. So I'm aware that stare decisis is not a sufficient argument. So I go on to say this is also a matter of originalism. And I quote Alexander Hamilton from Federalist 78. To avoid an arbitrary discretion in the courts, it is indispensable that they, meaning the judges, should be bound down by strict rules and precedents, which serve to define and point out their duty in every particular case that comes before them. And end quote. So this idea, I mean, of course, I'm not a fool. I understand that not every previous court decision was rightly decided, and every now and then they are overturned. But the weight they should be given, I think, is fairly considerable, particularly when, and this is my core argument to you, Hugh, particularly when a decision like Roe or Casey has advanced to a huge class of people a right that they have enjoyed and taken for granted for generations. That, I think, is something that deserves a hell of a lot more consideration than the question of whether corporations should be treated as having as enjoying First Amendment rights.
Well, this is where we fundamentally disagree. They have not taken it for granted. As you have seen, the abortion debate is never ending, and it will never end because it concerns first principles on the status of the unborn child. And I don't think anyone argues that it's not a child in the 9th month. A lot of people argue that early term abortions in the first month don't make a difference. Mm-hmm. And by the way, I don't believe there's any way a court is going to strike down because of the Commerce Clause, the FDA's decision to license the morning after pill. And there's no way that the court is going to wade into the California constitutional framework. When they are done with it, they're going to be done with it. And here is the key argument why I think yours is the radical position, not the conservative position. The abortion jurisprudence continues to distort and pervert our law in other areas, especially with regards to free speech, especially with regards to First Amendment rights. And Justice Scalia used to say, unless until we get rid of the idea that a majority vote of 9 unelected people makes the law in the United States, we are in a world of hurt. That's a paraphrase. And we're going to see that again. And Bret, it's just never going to stop because it's a religious matter. And unless you trust the people of the states, or you get 60 votes to pass the radical law that Chuck Schumer wanted to pass, we are just postponing and continuing the fraying of the national conversation.
Look, in some sense, I agree with you, Hugh, which is to say that if, in fact, this decision comes down substantially the way Alito has written it on a 5-4 or 6-3 vote, the abortion argument is going to continue. In fact, I think it's going to do more it's going to make our politics more vicious. I think it is going to degrade the integrity of the court. This leak of the decision, which I rue and condemn, and I think is a horror, along with protests outside of the homes of justices, are going to become that much more intense. And that's why I say to you, Hugh, this is going to be the domestic policy equivalent of American troops in Baghdad, which is going to be something we will regret in later years. I guess that I think that the expression is Pyrrhic victory.
And what I say to you, if we're going to use that analogy, eventually you have to withdraw from a field that is contested. You don't want to withdraw like we withdrew in Afghanistan, unannounced, without anyone knowing and without any kind of security for those on one side. But the court, to save the court, has to get out of this forest, Brett. I've been trying to make this argument for 25 years. I'm not making a life begins at conception argument. I'm making a Federalist 78 argument. It's the weakest branch. It needs to restore its credibility. This is why, by the way, I think the Chief Justice assigned it to Alito and will concur and will point to his concurrence in Citizens United about stare decisis.
By the way, in that respect, I suspect that you're right about Roberts's vote. This is not going to end this. It's not going to end it at the court level. The 6-3 conservative majority won't last forever, and this battle will never end. We had something like a settled consensus in the United States. Abortions were actually going down in this country, which is I think everyone would agree, is a good thing. This is just going to be another upheaval in a world already riven with upheavals.
And we disagree about how to get to peace, though we both want to get to peace. Let me close with this. I don't know if you focused on Justice Alito's comment that the standard that will replace the scrutiny of Casey will be the rational basis test. I believe that the court will strike down any complete ban on abortion that prohibits early term abortion. I believe they will count that as irrational and that it is not in keeping. And there are a bunch of precedents like City of Claiborne and other places where rational basis doesn't mean that legislatures get a free pass. If radical laws are passed, especially any law punishing a woman getting an abortion, those laws will be struck down. I really do believe that.
Why?
Because they are irrational in the way that Claiborne.
Why shouldn't the court? Here's the weakness of your argument. Why shouldn't the court leave that to the states to decide?
Because the rational basis test has been articulated for much longer than 50 years and goes back indeed to the beginning of strict scrutiny, which is the famous footnote 4. And I don't want to teach con law on the radio with you, which is when something so offends so much of the country, the court will rise up and strike it down, as they have done repeatedly under rational basis. And I do believe there is an enormous 90% plus consensus in America to leave this to the states. I believe it is a supermajority position to leave it to the states, but I also believe it's a supermajority position that if you attempt to ban abortion in the first month or the day after pill, the morning after pill, the court will reflect that consensus under a rational basis review. If I'm right, Brett, does that ease your mind about where we're heading, which is to stasis with women on notice and men on notice that any mistake they make with regard to pregnancy should be remedied early if they think it's a mistake? Now, I'm not making a moral judgment. I'm Catholic. I believe life begins at birth.
You've just made my argument for me, and you've essentially rested the future of abortion and, in fact, of other reproductive freedoms in the hands of states who may be much less liberal-minded than even you argue.
I am completely at ease with that because I believe, as Churchill did, trust the people. And if the Federalist, not just 78, but anything, can be understood in their entirety, it comes down to we have dual sovereignty and we will trust the people of the United States when they act according to their...
But one last point. The entire Constitution of the United States, the entire structure of government, checks and balances, the existence of a Supreme Court, John Marshall's jurisprudence is all about not entirely trusting the people.
It is about not entirely trusting the people on the limited and enumerated powers that have been delegated to the Congress. And when we break out of that constitutional construct, when we take away the right of states to control the dual sovereignty that was created in 1789 and ratified by the people, not by the states, we risk becoming one government, which is the nightmare. Then it becomes the opportunity, the invitation to authoritarianism, which so many people worried about for so long under Donald Trump and under other political figures in the past, Brett. We've got to stick with the Constitution.
Thank goodness for the 14th Amendment, which made us a hell of a lot more one government and less a federal system in which particular states could pass laws that vitiated the fundamental rights of large portions of their citizens.
And Brett, last phrase. Our Section 5 of the 14th Amendment provides the Congress with the United States with the authority to enact laws to further its purposes. If and when there is a supermajority to do that in the Senate, because I know you're in favor of the filibuster as I am, then I'm going to shut up. Because then because the 14th Amendment is very much a part of the Constitution, as is Section 5, and that allows for the sorts of laws that Chuck Schumer tried to get passed and could not even get a majority, including members of his own party, to support. We are not a radical country on this issue. We are a leave people alone country, but protect children in the womb when they have become indeed unarguably children.
Yes, and at the rate that this court is working, Chuck Schumer might just get that majority.
He might, but you know, can I ask you? You don't think Obergefell, same-sex marriage, is under no threat nowhere, anywhere in the United States? Contraception is under no threat nowhere in the United States. By the way,
absolutely, Obergefell is under threat. I mean, what is that? 2015, a 7-year precedent based on a Supreme Court decision against the will, at least at the time, of a majority, if not a large plurality of the American people. So I do think that's realistically under threat, which is another reason, not enumerated in my 825-word column, why I think overturning Roe, I think, sends shivers up the spines of people who are enjoying rights that, as you put it, or as Alito put it, nowhere existed in the early days of the Republic.
And Bret, here's the key. If you write that column, go and try and find one state law that attempts to inhibit Obergefell or one that attempts to control contraception. One state law that is passed. None exist, none are proposed, none are coming. We constitutional law professors deal with the world as it is, and that threat does not exist. And I don't want to scare people. It just doesn't exist.
Well, let's revisit this argument. If this decision goes the way both you and I think it will go in, say, 5 or 10 years' time.
Deal. Bret Stephens, always a pleasure to talk to you. Thank you for joining me
Thanks
this morning. I
me on.
appreciate it.
Be well.
You bet. Be well.